And good morning, good afternoon, good evening, ladies and gents. This is your boy Casanova from Orlando, Florida, on this awesome and international podcast, Good Wine and Great Laughs. The podcast for wine lovers, ladies and gents. Summer movies, reviews, and hot topic discussions, ladies and gents. I'm Casanova, your host. Welcome to Casanova. If you're new to my YouTube channel, ladies and gents, what I do here every Saturday morning, I have the wine of the day, ladies and gents. I'm going to open this wine shortly. I'm going to taste it. I'm going to give you some information about the wine, and I give my rate. My rate's always 1 through 10, and I let you know what I think about this wine. If you like my review about the wine, you'd like to find out about this wine, get one bottle. The picture of the wine of the day is always posted on all my social media, such as Fanbase, Instagram, Facebook, all this good stuff right there. It's going to be, you will see a nice picture of the wine of the day, ladies and gents. During the summer months of June and July, I take a break of hot topics and I have summer movies reviews. So the new movies that come out in movie theaters, or there's a brand new movie that come up on Netflix, Amazon Prime, Apple TV, all these applications that I have most of them. I'm gonna watch this. I found someone watching, and I make a movie review for you. And also the rest of the year, I have hot topic discussions, ladies and gents. And hot topic discussions are always topics that can affect our lives directly or indirectly, ladies and gents. So if you love wine, if you love some summer movies reviews, and if you love hot topic discussions, this YouTube channel is for you. If you like the work that I do, ladies and gents, I'll ask only 3 things. Please subscribe to my YouTube channel. Click on the like button of any videos that you watch from this channel, and share any of my videos with at least 5 people you know. I appreciate the support. And I'd like to thank the new subscribers that came to my YouTube channel after the last episode related to the UN vote about the slavery as the terrible human, you know the topic. Verse number 12. I appreciate you. Thank you. I love with all my heart. Welcome to Casanova, ladies and gents. So today is Saturday, April the 4th, 2026, and the weather here in Orlando to be a mix of sunshine and clouds. Highs of 84 degrees and lows of 66 degrees, ladies and gents. All right. So before I talk about the topic of the day, let's talk about the wine of the day, ladies and gents. So I'm just give a little things that happened to me this week. Very busy week. I was supposed to come out of town to Orlando on Friday. Flight got canceled and I have to wait. It took forever. So by the time I got home, it was very late. I did not have the chance to go to the wine store to get a new wine for today's episode. So I look at my wine collection and I select PAPI. This here, I already presented this before, but for those that did not see the episode, so that's the remix. This is PAPI. It's a Chilean wine, ladies and gents. It's PAPI Sauvignon Blanc. It's a vintage of 2024, right here. And according to the label in the back, say PAPI, the fun start here. Softly sweet, located in the heart of the Chile's famous Central Valley grape-grown region. PAPI's portfolio of wines specialize in classic, young, and versatile style wines. Only select hand-picked grapes and a careful winemaking process allow us to present this new best wine. Discover the PAPI difference, ladies and gents. Alcohol percent of this wine is 12%, ladies and gents. Once again, the Sauvignon Blanc, vintage of 2024 from Chile. I already had this wine, ladies and gentlemen. I'm going to drink again. And I'll tell you right now, ladies and gentlemen, all PAPI wine, red and white, that I had and I have, that I can find, I have all on my wine collection. One is better than another. So, PAPI and all the bottles, ladies and gentlemen, can find for less than $10. So I know what's going on in the country. The economy suck balls. It's terrible right now. Gas prices going sky high. Grocery prices going sky high. And so, if you love wine and it's under budget like most of us, definitely I recommend for you to find and drink PAPI. I don't have no sponsorship of them, ladies and gents, on this YouTube channel, but I definitely have to give kudos to who deserves, where kudos is due. Nice, beautiful color, very clear, nice and crispy. The bouquet with this wine is perfect, ladies and gents. Nice, very delicious smell. A hint of citrus flavor. Now you can smell that. Very crispy, ladies and gents. There's a delicious, delicious hint of sweetness mixed with a hint of lemon skin. You know, like a use that little skin for the zest of the lemon skin. That's something. The zest of the lemon skin on the back of a palate. That's completely a mix of sweetness, and the lemon zest is, in my opinion, is perfect. Give a 10, 10, 10 for PAPI. Kudos, great wine, ladies and less than $10 a bottle. Well recommended. All right. So let's talk about the topic of the day, ladies and gents. And the good thing about making this podcast is because, you know, I just do it once a week because I gotta balance my work schedule, and I also keep watching the trends of what's happening in the country. So I was looking for something, and then what happened? You have the Supreme Court Birthright Citizenship hearing. So the topic of the day for season 12, episode 13 is SCOTUS Birthright Citizenship hearing did not go well for Trump. I like to give credits, ladies and gentlemen, to Roland Martin Unfiltered and Legal AF. Check this guys out, ladies and gentlemen. The description is right there. The link is right on the description, ladies and gentlemen. Click on the link. It's going to take directly to their channel. And Michael Popoff, ladies, if you had never heard about him, on Legal AF, he's a great lawyer, and I like his analysis. Anything related to any cases, because he breaks down the lawyer terminology and explain on very simple terms to anybody to understand what happened in court. So that's what I'm going to do. I have the first video is going to be what the news that we're talking about before the hearing that was on Wednesday. That's going to be the first video. And the second video comes Michael Popoff explain what happened in court and the breakdown of the justice speaking and how Trump got his ass whooped. I love it. So enough talking, ladies and gents. Let's watch these videos right here. I'm keep doing this wide, and when I finish these videos, like I always do, I give you my 2 cents, what I think. So it is showtime.
All right, the racist actions of this administration continue. On Wednesday, the Supreme Court will consider the twice-impeached, criminally convicted felon-in-chief's efforts to end birthright citizenship, which a federal judge blocked in July. Legal scholars say the administration is citing arguments from an 1896 Supreme Court case that established the separate but equal doctrine, which supported Jim Crow laws. These arguments were originally made by Alexander Porter Morris, a Confederate officer during the Civil War and a Louisiana attorney who advocated for legalized segregation in that landmark case. Now, keep in mind, when you go back to the Reconstruction era and you begin to unpack that particular era, what you actually are dealing with is you go from Dred Scott decision in 1854. You're going through, of course, the end of slavery with the 13th Amendment. Then you get the 14th Amendment and the 15th Amendment. Those were the three Reconstruction amendments. And you go, of course, to the election of 1876, the contested election, the Great Compromise of 1877. Then you begin to see a Supreme Court invalidate legal rulings like the 1875 Civil Rights Act. And then you go to 1896, Plessy versus Ferguson. We've seen this happen over and over and over again. And so what Donald Trump is trying to suggest, and you put out a Trump Truth Social post. If y'all have the post, pull it up, where he argued, and Republicans have been arguing that the 14th Amendment only applies to the children of enslaved people of African descent. Let me say that again. They say it only applies to them. And so what they have been suggesting, and this is all a matter of them targeting undocumented workers in this country. This is what their entire strategy has been. And so they have been wanting to get rid of this. And so what Trump did was he signed an executive order invalidating the 14th Amendment. Okay, first of all, an executive order cannot invalidate a constitutional amendment that was, of course, approved by Congress, ratified by the states, and then placed to the Constitution. Executive order cannot do that. But that wasn't the point. The point of the executive order was for this case to go to the Supreme Court, because he believes by having 6 conservative justices on the Supreme Court that he can actually win this case. That's what this is all about. And so you've got these FBA folks and others who say, oh, no, this is perfect because the 14th Amendment only applies to us. When, since it was ratified, the 14th Amendment has applied to anybody actually born in this country. So conservatives, Republicans, MAGA, they have been opposing what they call anchor babies. And so what they want to suggest is that you get rid of this provision, and by getting rid of this, and as a result, anyone who's actually born in this country, it will not apply to them. That's what they are trying to argue before the United States Supreme Court. And now, when you look at the rationale again, they're using a racist, a segregationist to support their argument.
Right.
And what they've been trying to do is to get African Americans behind this. Some have fallen for the okie doke by suggesting that, oh, well, this only applied to Black people, folks who were enslaved, or the children of folks enslaved. That's what they have been focusing on. Joining me right now is Yannick Gill. He's a human rights lawyer. Yannick, glad to have you here on the show. Look, we know exactly what the game is. And so they want to target folks who have come to this country, born in this country. And so they want to call them anchor babies. They want to target Black immigrants who have come here from Jamaica, from African nations, from the Bahamas, from Bermuda and other countries, people who were born here because based upon the 14th Amendment and based upon prior precedent, if you are born here, then you are a United States citizen. They want to get rid of that part of the 14th Amendment, and they hope that this right-wing MAGA Supreme Court will let them.
The Constitution is clear, Roland, and the court must be too. This is a question beyond just law.
Right.
You hit the nail on the head when you brought up our culture. You brought up who is American. And you cannot separate this analysis of the 14th Amendment, law that has been established for well over 150 years, and the current mess that exists within MAGA country. You see, it's primarily non-white people being born in the United States, and they're scared. They're scared of what will happen when there is a voting electorate that is not supportive of MAGA policies, and diversity continues to rise. You see, the numbers are in our favor. 1.8 million U.S. citizens were born to two parents from a different country. Currently, 4.8, almost 5 million people were born to at least one parent with either a regular status or a conditional status. Think a H-1B visa, meaning they're here seasonally, or even a student visa. The law isn't meant to be changed to where people will be born and not recognized by our Constitution. Not only is it unconstitutional, but it's definitely not something that one man trying to be a monarch can change through an executive order.
But here's the problem. But here's the problem. The 14th Amendment was ratified in 1868. That amendment reversed the Dred Scott decision, which took place in 1857. Here's the problem. The problem is that every time we have a Supreme Court nomination here, they talk about stare decisis precedent. But the reality is there really is no such thing as precedent, because a Supreme Court can overrule a previous decision. The fact of the matter is this Supreme Court could very well declare that this portion of the 14th Amendment is unconstitutional. And that's what we're facing. Remember, people also said, hey, the court's already decided precedent when it came to Roe v. Wade. This court, in a case where they were not even, the Mississippi folks were not even asking for Roe v. Wade to be overturned, they went as far as to overturn Roe. So they even went beyond the case that was in front of them.
And that is the danger of the Supreme Court. We have allowed the president to pack a court that is clearly political. And if you just look at the legal decision that they're focusing on, there's 5 words that are at the core of this case on Wednesday: subject to the jurisdiction thereof. But we know how the law works in the United States. We don't care your nationality, your creed, your race. If you're in the US, the law applies to you. Now, there's some discrimination with how it's applied, but anyone born in this country is subject to the jurisdiction thereof. This would be another brazen attack on our Constitution, on our civil rights, on American culture, for them to take away something so inherent, so basic to what it is to be an American.
But again, I want people to understand that this court does not care about precedent. If you look at the rulings that they have made when it came to presidential immunity and just pretty much granting that a president can do anything they want to do, and they ruled in that case for Trump, and he wasn't even, the issue in front of them, he wasn't even in the Oval Office when those issues came up. And so this right-wing court, okay, positioned by the Federalist Society, positioned by the right wing, this is really the mother lode for them. They were focused on, yes, Roe v. Wade. They were focused on 14th Amendment. And they also want to completely invalidate 1965 Voting Rights Act. And so people need to understand what we're dealing with here.
Right.
The Supreme Court is the final arbiter. There's no one above them. And so when people say, well, you can pass a law to overturn the decision, but here's a law that was already passed that has been on the books since 1868 that they very well could invalidate and rule unconstitutional.
And you have hit the nail directly on the head. We have seen the Supreme Court time and time and time again rule against black letter law, against well-established precedent, to just follow whatever it is that President Trump wants. You're completely right. The Constitution should protect for this. Our precedent should protect for this. But we're in a time where MAGA not just is in the White House, it's not just in Congress, but they're also in the Supreme Court. And so Wednesday's decision can have a massive rippling effect, not just to Latinos or undocumented immigrants, but as you aptly noted, to the Black community. Because, as I continue to say, on its face, you cannot tell who is an immigrant and who was born in this country. And we're seeing the chaos that's causing in Minneapolis.
Bringing in my panel right now, A. Scott Bolden, attorney based out of Washington, D.C. Also, Thelma Anderson, creator of the Public Opinion Court, author of Shut Up and Prosecute out of Dallas. Dr. Ome Congo, being a senior professorial lecturer, School of International Service at American University, author of Lies About Black People, How to Combat Racism. Scott, I'll start with you. Again, I need people watching to understand all they need are 5 votes. There are 6 MAGA jurists on the Supreme Court. Okay, you've got Sam Alito. You could pretty much say Alito, he's going to rule with Trump. Okay, Clarence Thomas absolutely is going to rule for Trump. You've got Neil Gorsuch, who's on the court. You've got Brett Kavanaugh. You've got Amy Coney Barrett. You've got John Roberts. The reality is, out of those 6, Coney Barrett and Roberts may be the 2 who don't flow the direction of the other 4. But people need to take this seriously. You cannot trust this court to say precedent stands, Scott.
Yeah, but here's the deal, and hello to your guests for bringing us some legal knowledge on this issue. As the son of a judge and who spent time on the Court of Appeals in the state of Illinois, it doesn't really matter if you are conservative or whether you're liberal based on your appointment. With the plain language of the Constitution, you got to do something with it. You got to get around it. Whether you're conservative or liberal, you still got to write an opinion that is legally and factually justifiable. And so my question to your guests, and I've been struggling with this over the last several months about this birthright citizenship, is in order for the conservatives 5-4 or 6-3 to get around the plain language of the Constitution, there are not many cases to go to the Supreme Court where it's going to rest on those 5 words. They've got to figure out a way around it. They've got to, if it's not stare decisis, they're not going to recognize that. Then how do they get around the plain language?
Easy.
You can't just sit there. You can't just ignore it.
Easy.
I'd love to hear your guests talk about that pathway around it.
Yannick, go ahead. I'll be happy to answer Scott's question. Yannick, go ahead.
I think that we are giving them more credit than they deserve. We have seen, whether it be the Roe v. Wade decision.
Me or Roland?
No, I'm definitely talking to you, sir. Not Roland. Apologies.
Okay.
Yes,
okay.
I think there's a little bit too much faith that the Supreme Court is going to follow black letter law, and it's been shown time and time again that they will twist and interpret and redefine well-established precedents in ways that any first-year law student would laugh at. It's not a legal question anymore. You cannot separate the politics from their analysis.
Yeah.
Well, listen, I can easily answer that question. It's called originalism. What the right wing has always maintained, they've always maintained this idea of what was the original intent of the framers? What was the original intent of Congress? And what Donald Trump, and what they have been arguing is that the original intent of the 14th Amendment was not for it to apply to anybody in the future. They're arguing that the intent is that it only applied to the children of formerly enslaved people of African descent. And so their argument is that the 14th Amendment ends right there when it comes to that it only applies to the children and the descendants of the people, people who are formerly enslaved.
But Roland, that is an extremely narrow
that's the point,
focus.
Scott.
Originalism, if I may, originalism encompasses the concept of what you're talking about, but the reality is that originalists will look at the plain meaning of the words. They don't give up on it being a living document, so it is a living document. And the plain meaning of
Scott,
that language,
they only believe it's Scott. They only believe
those 5 words to the jurisdiction.
Scott, they only believe it's a living document when it applies to what they like.
Exactly.
And that's what this whole problem is. I mean,
you're talking about politics. I'm talking about legal jurisprudence.
No, Scott.
Two,
Scott, a
you've
Supreme
never been
Court
to law school and I
Scott,
have. Let me coach you on this.
Scott, hold on. Let me coach you, Scott, on politics. Scott, let me coach you on politics.
What?
A Supreme Court nominee.
Let me coach you on legal jurisprudence
Scott,
first.
a Supreme Court nominee.
Like a lawyer.
Scott,
you ain't got a degree behind your name.
A Supreme Court nominee, Scott, listen. A Supreme Court nominee is picked by a president. A Supreme Court nominee is confirmed or denied by the Senate. That's all politics. This notion that we can divorce politics from the law and the court is absolutely, that's like being on meth. Okay, you're high. You can't divorce that. You can't divorce it.
But I'm not divorcing the politics of it. What I'm saying is, once you get to the Court of Appeals, the Circuit Court, even federal district court, right? You could be a conservative or liberal. You still have to have a legal and a factual pathway to get to a conservative decision.
They will create
with
one.
you or your guest. What I'm saying is there is a legal and factual pathway, and what we need to really be exploring as we oppose this is One, what's that pathway outside of the political piece? Because you're going to go with the politics and say they're just going to write something to serve their purpose. I get that part. But they also have judicial canons of ethics and judicial strictures that they've got to fit into in order to reach a decision that the Trump White House wants them to read. And all I'm asking your guests, and all I'd love to talk with other legal scholars about, is how best do you do that? Because then that's how you oppose it.
Thelma,
that's all I'm saying.
I'm gonna bring Thelma in here. Thelma,
I don't think the lawyers disagree with me on that.
Yeah,
do you?
Thelma, bring you in here.
That pathway.
I'm bringing Thelma in here. This is the real issue we're facing.
Did you do that?
No,
Did you do that?
Scott, chill. Thelma, this Supreme Court knows that they are the final arbiter. They don't give a damn about legal precedent. They don't care about, well, let me come up with the right. They know at the moment they decide, that's it. Until there's a new court. They don't care what Scott just said.
I totally agree. And I slightly have to veer off with Scott on this because coming from the government as a former prosecutor and a former magistrate judge, I saw firsthand how politics played into the law. That, when I tell you, that literally changed how I navigated in the system, because not once did I think that the law was going to have to worry about being interfered with politics, but politics have more power in the law than we know. So when we're talking about what the Supreme Court is going to do, yes, we think that they're supposed to, we know that they're supposed to. However, they get to make their final decision because they have been put in a position to do it so freely under this administration. So we cannot minimize how powerful this particular case in the hands of some of the most uneducated, in my opinion, to the level degree that needs to be on the Supreme Court to follow the black letter law, because they're supposed to follow the black letter law. And one of the main words that is very clear in the 14th Amendment is everybody. It does not give a description. It does not say everybody, but it says everybody. And for them to come in and interpret it that way, that is because they have injected politics into the rule of law. And when you have the majority on the Supreme Court, they get to will and deal how they see fit, regardless of what their judicial responsibility is. And we've seen that this Supreme Court does not give a damn about their judicial responsibility so long as they're doing what the person that put them in that seat to do.
Scott, 1 second.
Hold on, let me respond.
Scott, hold on. I'm gonna let you respond after Ome Congo speaks. Ome Congo, I'm bringing you in here. The point that what Scott was addressing earlier, and then what you just heard Thelma say there. Let's take the Second Amendment for a perfect example, okay? When you talk about what the words actually say. Anthony, go to my iPad. I remember, folks were saying, wait a minute. The Second Amendment doesn't say anybody can have a gun. The Second Amendment says a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms should not be infringed. Now, when that case came up, there were many who said, oh my goodness, that applies to a militia for the state. Right. The purists say, oh no, that means everybody can have a gun. Any gun, how many guns you want, as opposed to an actual organized militia, which is an actual unit versus an individual. What we're dealing with here are 6 people, but it's really 4. Actually, I'm going to say 6. 4.5, 5, because Roberts ain't a moderate. Coney Barrett ain't a moderate. But considering how crazy the other 4 are, they might be deemed a moderate. These folks here, they know they have the power to literally rewrite law. I don't trust these people to respect precedent, to respect jurisprudence. I don't trust them to do anything that Scott said. I believe these folks are saying we can do what the hell we want because we have the power to actually do it, and literally no one can stop us. Ome Congo, hold on, Scott. Ome Congo, your turn.
That part.
Look, my legal analysis only goes up to about Law and Order. I've watched every season as far as I go. But on the political side of this, we have to be mindful of the fact that the courts, the Supreme Court, over the years, it has primarily granted rights to various individuals. This is the first, Supreme Court that we're seeing that is actively working to take rights away. And we know it's also going to be coming with the Voting Rights Act as well. And so when we talk about, what the letter of the law, we have a Supreme Court. These justices, they don't care. And they, outside of the tariffs, they pretty much ruled with Trump on pretty much everything, because that was something that was going to affect their dollars. So we can't take this court from what the law says, what the Constitution says. We have to take them as they are. And this is led by Roberts. This is a Supreme Court that is hell bent on reversing the rights of pretty much everybody who is not a cisgendered white male. And they're going to do whatever it takes to do that. And their mindset has always been damn the law. So this is not, regardless of what the law, the jurisprudence and all of that, this Supreme Court has demonstrated completely that it cannot be trusted to do the right thing. Case in point, I remember when the immunity case came out, and I was seeing all of these guys, J. Michael Ludig, all of these conservative judge luminaries who were saying, "Oh, this is a drop case. It's going to go nowhere. They're going to send it back to the lower courts." And what did we know? They gave him immunity pretty much over everything, which is allowing him to engage in his criminal acts right now and his unconstitutional acts right now. And so, just on that fact alone, this is a reason why we should not trust this court. I love what's being said here on the panel, but we shouldn't trust this Supreme Court to do that based on what the record shows as well.
All right, Scott, now you can talk.
Yeah, guys, real quick, two things can be right at the same time. I don't disagree with you that they're not trustworthy. And I understand the abortion decision, the immunity decision. I was one of those talking heads saying they'd never do that. Got it, right? The point I'm making is what makes this unique. One, politically, they would have. How do you look at the tariff decision? I can still distrust them, but the tariff decision, where they went directly against the president on something that was near and dear to his heart and yet was killing our economy. So there is some glimmer of hope there. But the fact of the matter is, when you've got a case like this, just consider this, where the plain language of the Constitution is there, subject to the jurisdiction. You've got to do something. I'm sorry. You got to do something to get around it as a conservative jurist. You can't just ignore it and say, this is how it's going to be. This is what it's going to be. Now, Roland, I like your argument saying, hey, the originalists will say, well, this is what it was meant to be. That's true, but that seems to run out a little bit because we're in 2026. So that alone won't sustain it. And because it is a living document, regardless of what originalists think, it's been applied. And you do have precedent that say that if you're born here, you automatically become a citizen. At least 20 other countries say the same thing. So it's not that far-fetched. I practiced with Roberts. I practiced against him before he went to the Supreme Court. I do believe he's a moderate, deeply concerned about being a political court, notwithstanding some of his decisions. And I got to tell you, this huge, huge impactful decision that's going to be he's writing or somebody's going to write, I can tell you at the forefront is, why am I going to be a political court, or why am I going to be dragged into this political process? I don't want to get this wrong. And I do think there's hope. That's all I'm saying is there's hope.
Yannick, before you make your point, let me be real clear. Roberts is irrelevant. They have 6 votes.
Right.
Yeah, no. Scott.
And I got to tell you,
Scott. Roberts could roll with Ketanji Brown Jackson, Sotomayor, and Kagan. It's still 5-4. And this is, and Yannick, this is the point that people need to understand. I listen to so many people. Matter of fact, I'm even go before Hillary. When Obama was there, Rahm Emanuel, one of the reasons why I will never support his sorry ass for the Democratic nomination, Rahm Emanuel used to shit on progressives because all they talk about is the goddamn court and the federal bench. Yeah, dumbass. Because at best, Obama was going to be there 8 years. Federal judges can be there for 30, 40, 50, 60 years for life. And so what ended up happening? I remember people all the people were sitting here saying, oh, Supreme Court, the Breonna Grays of the world, Supreme Court not going to be an issue when Hillary was running against Trump in 2016. Was it? Yes. Trump got three Supreme Court picks. I remember, listen, Obama people were pissed off at me when I was lighting his ass up when he nominated Merrick Garland. I'm like, dude, ain't nobody fighting for another white man. We had, 105 in American history, and then 105 out of 109, whatever the number was? No. I knew that was going to be a major issue. And so for people who are sitting their asses at home, who say elections don't mean nothing, my vote doesn't matter, well, guess what? Your lack of voting is the reason why Trump got 3 votes on the Supreme Court. The reality is this, Yannick, if 2016 election had gone different, progressives/liberals would have a majority in the Supreme Court right now. It would be 6-3 progressive/liberal versus 6-3 MAGA conservative.
Let me add.
Hold on, Thelma, 1 second. Yannick, go.
Yes, and you're completely right, and we wouldn't be dealing with this mess, this ideal that the law and the politics are separate. We know that judges and who they're appointed by matter so much in how they decide and interpret the law. And this is part of the reason that this case is even coming up. Let's be clear. I get this idea that the language is very clear, subject to the jurisdiction thereof. They can interpret things however they want. The same all persons is very clear, right? But when this law came out, when this was originally decided, that didn't include Native Americans. It was interpreted to strictly be the descendants of chattel slavery. How things are interpreted will intimately be impacted by the politics and who is reading. More importantly, who their audience is. I'll end with this. Keep in mind, this is the same person, the same president who entered into the political world by challenging what? The citizenship of President Barack Obama. This has always been part of the larger conversation. Anyone who is deemed non-white will have their citizenship challenged because they don't want them to vote. They don't want them to be part of our electoral process. Notice they didn't do this with Rafael Ted Cruz.
Right.
Why? Because he acquiesced and assimilated in ways that Vice President Harris could not, which was challenged, in ways that President Barack Obama never did.
Thelma, go ahead.
I think one thing that we also need to pay attention to is how do we get here from the standpoint of the federal benches, which is very important, because when you look at the qualifications for these individuals to interpret simple law, that plays a big role in how these cases are getting to the Supreme Court. For them to have this ability to have the power that is immured in politics, we have this problem because of that. Look at the individuals that were the Senate was overlooking last week with their nominations for the federal benches. No qualifications whatsoever. Never tried a case, never did any kind of criminal work, never did any kind of work that qualifies them to sit on a lifetime bench.
But that's why they want them. That is literally why the Federalist Society, listen, they purposely, Mitch McConnell made it clear, we want to appoint people 45 and under. They appointed people to the federal bench who had graduated from law school 10 years ago. Folks who had never even gone into a courtroom. Folks who had never taken a deposition. So we have to understand what their whole aim and goal here is. And I'm telling you right now, I don't trust this court. There used to be a belief, especially among African Americans, that you could trust the Supreme Court, that you could trust the Constitution, that you can trust the law. One of the reasons, whenever I hear these right-wing people talk about black people in the federal government, not understanding that black people knew and understood, I'm going to cover this in less than 30 minutes, black people knew and understood they couldn't trust states, especially southern states. And so the only redress we had was the federal courts. The only reason we were able to defeat Jim Crow was because of the federal courts. Dr. King often said, be true what you put on paper. The problem what these folks want to do, primarily, Yannick, because of the Black freedom movement, the civil rights movement, because all of that, they are literally angry. They believe that the fall of America, the decline of America began with the 1964 Civil Rights Act. The 1965 Voting Rights Act, 1968 Civil Rights Act, Fair Housing Act. In fact, let me take it back. No, that was the second Reconstruction. They actually believe the decline of America began with those first three Reconstruction amendments, the 13th, the 14th, and the 15th. So it's no shock that they are attacking voting rights, 13th, they're attacking the 14th Amendment, and all you women, white women, guess what? They also hitting your ass when it comes to voting too. So they believe, I don't trust the people at all. You have a significant number of them, Yannick, who believe that this country was meant to be controlled, run, and decided by white men.
Rich men. White rich men.
And it's clear, as you pointed out, with the SAVE Act, it's clear with how you're seeing the Supreme Court pull cases that should have never made it this high. And you're hearing it black and white from the President of the United States, not on a hot mic, not on a leaked memo. He's saying it to our faces. This is the same president that, again, has been attacking folks, black folks, Latinos, the Muslim community outright. You cannot separate citizenships and attack thereon from white supremacy. It's a core tenet of it, whether you call it white nationalism, white Christian nationalism, white replacement theory, it's all one and the same. And attacking who is a citizen, who has a right to vote, who has a right to stand in a room and get an education, has been part of the playbook for centuries.
Absolutely. Well, we'll certainly be waiting for those arguments on Wednesday. Yannick, we appreciate it. Thanks a lot.
Did the United States Supreme Court and its right wing just troll Donald Trump in response to him being the first sitting president to arrive at a Supreme Court oral argument and the first one to leave in a huff after 45 minutes because he didn't like the way the right wing was treating his Solicitor General and the fact that it looks like they're not going to side with him to rip the beating heart of birthright citizenship out of the U.S. Constitution? Breaking news, folks. A skeptical and scornful United States Supreme Court held oral argument today. We had it up live on Legal AF YouTube channel right here. And during it, Roberts, Chief Justice Roberts, Amy Coney Barrett, Gorsuch, and Kavanaugh took turns beating John Sauer, the Solicitor General, like he was some sort of jurisprudential piñata about his illogical gaps in legal reasoning argument to suggest that the 1868 amendment, the 14th Amendment, the Clause 1 Citizenship Clause, is only about the babies of former slaves. That's not what it says. It says a person who was born in the United States or naturalized in the United States and subject to the laws thereto is a citizen of the United States. John Sauer wasted a lot of his time talking about birth tourism and 8 billion people that are a plane ride away in the modern world from getting U.S. citizenship. And he was met with a withering response from John Roberts, who said it may be a new world, but it's the same old Constitution. At that moment, which is about 40 minutes into the oral argument, John Sauer, sort of like Weekend at Bernie's, was dead. He just didn't know it. He was traipsing himself around, with sunglasses and a baseball cap for the next 2 hours, but he was dead as soon as Chief Justice Roberts did that. And that was about the moment that Donald Trump had seen enough. And much like he walked out on the E. Jean Carroll sex abuse trial during closing arguments, pissing off the jury, he did the same thing again today. You're on Legal AF. Take a minute, hit that free subscribe button, help us continue to grow our channel. Let's get to the breaking news. So you had, if you were, I was concerned, and I've expressed it in prior hot takes, that they even took this case because there's only 4 giant pieces of this puzzle. That's it. It's not like one of these Paris Eiffel Tower Statue of Liberty puzzles with 5,000 pieces. You used to have to spend all summer doing. It was 4 big pieces. It was like a toddler puzzle. Wong Kim Ark, a case from 1898 about a Chinese American, a baby born in America to Chinese parents and whether they were American. And they were, says the Supreme Court, Justice Gray in 1898. Then you had a 1940 congressional law determining who could be a citizen, exactly taking language directly from the 14th Amendment. That's during World War II. 1952, during the Korean War, did it again and didn't mention babies of slaves, as Donald Trump likes to refer to them, slave babies. And the 14th Amendment language itself. That's your four big pieces. You can sit and tap dance like John Sauer all you want for 2 hours or an hour, given his spot. But those were the moving parts of this argument. And on one side, you had Cecilia Wong, representing the American Civil Liberties Union and our democracy. And you had this existential fight over who's a citizen. And then you had John Sauer, Solicitor General, Donald Trump's former appellate criminal defense lawyer. And that was the case. And so I could have done an entire video just playing you Ketanji Brown Jackson and Sotomayor and Kagan. But isn't it more fun to play the rightest of right wing attacking John Sauer, ultimately Donald Trump's proxy, in front of Donald Trump? Let's start with at the moment, which was at the very beginning, where John Sauer was dead. He was dead man walking. He just didn't know it. In this exchange with Chief Justice Roberts. Play it.
Mess. Their interpretation has made a mess of the provision.
Well, it certainly wasn't a problem in the 19th century.
No, but of course, we're in a new world now, as Justice Alito pointed out to, where 8 billion people are one plane ride away from having a child who's a U.S. citizen.
Well, it's a new world. It's the same Constitution.
It is, and as Justice Scalia said, I think in the case that Justice Alito was referring to, you've got a constitutional provision that addresses certain evils, and it should be extended to reasonably comparable evils. He said that about statutory interpretation. I think the same principle applies here, and I think we quote that in our...
Now, piling on, right on cue, and as I had hoped, Amy Coney Barrett joining with John Roberts. I've said this is the Amy Coney Barrett court. She decides she's in the majority more than most other judges, and she's the one that is willing to buck the rightest of right wing like Alito and Thomas on a regular basis. Now, sometimes she joins with them. But on key fundamental issues like this one, I said, I don't see her siding with Trump. And here's a clip. Now you'll know why I said that. Play it.
Concept that creates allegiance. That's
General,
so
you said in your reply brief that the children of slaves who were brought here unlawfully, in defiance of laws forbidding the slave trade, would in fact be citizens. And we can imagine that their parents were not only brought here in violation of United States law, but were here against their will, and so maybe felt allegiance to the countries where they were from. And you say that the purpose of the 14th Amendment was to put all slaves on equal footing, newly freed slaves on equal footing, and so they would be citizens. But that's not textual. So how do you get there? You say it in just a few sentences, so can you elaborate?
Sure. If you look at I think if you look at the 19th century sources, what you see is that even though their entry may have been unlawful, 19th century antebellum law never treated their presence as unlawful. In fact, quite the opposite.
Which takes us to Gorsuch. Now, Gorsuch, Neil Gorsuch has frequently sided this term with Alito and Thomas on the far, far alt-right. More than I'm comfortable with. But he has on occasion, you can count him on half a hand, broken ranks and sided with the democracy. He did it in the tariff decision when he went after John Sauer, the Solicitor General, arguing then. He's done it in other matters. And he did it again today, this morning, when he went after John Sauer this way. And let me frame this for a minute. I told you Wong Kim Ark, the case from 1898. Of course, you have to acknowledge it if you're John Sauer, but John Sauer went too far. John Sauer said, I adopt the reasoning of Wong Kim Ark, and this is what Gorsuch said back to him on that. Play it.
I'm just working within your argument for a moment. Today, you can point to laws against immigration that are much more restrictive than they were in 1860. We really didn't have laws like that we do today until maybe 1880. So if somebody showed up here in 1868 and established domicile, that was perfectly fine without respect to anything, any immigration laws. There they were. And so why wouldn't we, even if we were to apply your own test, come to the conclusion that the fact that someone might be illegal is immaterial?
I would first cite Wong Kim Ark on that point, because Wong Kim Ark says you're...
Well, I'm not sure how much you want to rely on Wong Kim Ark.
But there is a statement in there that says, so long as they are permitted to be here. So Wong Kim Ark, keep in mind that by the time they decide Wong Kim Ark in 1898...
But that's 1898. Now I'm looking at 1868, you're telling me is when I should look, and the test for domicile. And the stuff you have about unlawfully present, it's like Roman law sources you're going to.
First and second restatements as well. And
then you've got Kavanaugh, who chimed in his own way, properly analyzing it when he threw this softball to Cecilia Wong for the American Civil Liberties Union, which drew laughs in the courtroom. Now you know why Donald Trump left so quickly? Play the clip.
This in your opening, that if we agree with you on how to read Wong Kim Ark, then you win. So that could be if we did agree with you on Wong Kim Ark, that could be just a short opinion, right? That says the better reading is respondent's reading. Government doesn't ask us to overrule, affirmed.
Yes.
That's that. Then last question though, why would we?
Amy Coney Barrett, back up for more. Okay. Again, while you're listening to these, you try to ask yourself, how does Donald Trump count to 5? I mean, not literally, although sometimes I question his ability to do that. How does he get 5 votes? From where? He needs to get, let's assume he has Thomas and Alito. That's 2. He needs 3 more. He's got to get the 3 from Roberts, Kavanaugh, Gorsuch, and Amy Coney Barrett. Okay? But where does he get it from? Here's Amy Coney Barrett again.
Okay, and let's talk about its applications. So, there are some, I can imagine it being messy on some applications. So what would you do with what the common law called foundlings? The thing about this is then you have to adjudicate. If you're looking at parents, and if you're looking at parents' domicile, then you have to adjudicate both residence and intent to stay. What if you don't know who the parents are?
I think there are marginal cases. That one, I think, has the benefit of being addressed in 1401F, where it talks about...
Yeah. But what about the Constitution?
Under the Constitution, domicile is a constitutional standard in all kinds of other situations.
Well, and it's hard.
Diversity jurisdiction, personal jurisdiction, sorry.
Well, yeah, and a personal jurisdiction, 1332, diversity jurisdiction. And the thing is, it has to be litigated because it turns on intent. And both the virtue of both jus soli and jus sanguinis, whichever one you pick, it's a bright line rule. How would it work? How would you adjudicate these cases? You're not going to know at the time of birth for some people whether they have the intent to stay or not, including U.S. citizens, by the way. What if you have someone who is living in Norway with their husband and family, but is still a U.S. citizen, comes home and has her child here and goes back? How do we know whether the child is a U.S. citizen because the parent didn't have an intent to stay?
I'd say make 2 points, one practical, one legal. The practical point is under the terms of this executive order, you don't have to, because the executive order turns on objectively verifiable things, which is immigration status. Are you lawfully present but temporarily present, or do you have an illegal status? So those kind of taking evidence, so to speak, on your subjective intent wouldn't be done. And as to the constitutional point, obviously domicile is baked into a lot of constitutional and legal concepts, and there may be situations where facts are determined. But if you look at the guidance that all the agencies did after this court in Casa said the agency could go forward to issue guidance, the guidance provides, I think, very, very clear, objective, verifiable approaches to doing this. And so as a practical matter, I don't think it's presented by this executive order.
Thank you, General.
And so not to be left out, Ketanji Brown Jackson, who, as I've said before, is my choice to be the next Supreme Court Chief Justice.
I agree.
Roberts could retire or something could happen, die natural causes. When a Democrat is in office, that position is open. And I think that Ketanji Brown Jackson gets elevated. This isn't a slight to Sotomayor or Kagan. I just think the intellectual heft and the future of the Supreme Court is being represented well by Ketanji Brown Jackson. Here's Ketanji Brown Jackson laying in from her perch into John Sauer. Play it.
Right. You will still get
You're not transparent. I'm just talking about the particulars, because now you say your rule turns on whether the person intended to stay in the United States. And I think Justice Barrett brought this up. So are we bringing pregnant women in for depositions? What are we doing to figure this out?
No, as I pointed out earlier, the executive order turns on lawfulness of status. So if you give birth to a baby in the hospital right now, it gets the birth certificate in the system. There's a computer system.
So there's no opportunity, there's apparently no opportunity then for the person to prove or to say that they actually intended to stay in the United States?
Absolutely not. The opposite is true. Their opportunity to dispute if they think they were wrongly denied, which would only happen in a tiny minority of cases,
after the
is
fact.
Directly addressing that guidance.
After the fact.
Yes.
After their baby has been denied citizenship, then we can go through the process.
Yes. And the way that, I mean, I'm summarizing because I'm not an expert in computers, but there's a computer program that currently automatically generates a social security number. SSA says, look, a social security number, non-citizens can have them if they have work authorization, so it doesn't prove citizenship. We'll give you a social security number, provided that the system automatically checks the immigration status of the parents, which there are robust databases for, and then it appears no different to the vast majority of birthing parents.
Thank you.
Now, Donald Trump is a baby. We know he's a baby. As soon as he lost the tariff decision, he went after those justices that he appointed, Amy Coney Barrett, Gorsuch, Kavanaugh, Roberts, whoever, you name it. Not Roberts, because Roberts was on before. All the ones that he appointed for being so disappointed in them. Play that clip.
And the Supreme Court, that's right, of the United States cost our country, all they needed was a sentence, our country, hundreds of billions of dollars, and they couldn't care less. They couldn't care less. And not that it matters, doesn't matter at all. But two of the people that voted for that, I appointed. And they sicken me. They sicken me because they're bad for our country.
Now, let's talk about Donald Trump's storm out and his posting about no other country sells its citizenship the way we do. I don't even know what he's talking about. And every time he starts talking about slave babies, I get nervous and upset. So he has a habit. It's a terrible tell. He storms out in court hearings that don't go well for him. He did it in the closing arguments of the second E. Jean Carroll case, in which she had already proved that she was sexually abused by him, technically raped, as Judge Kaplan wrote. And he didn't like the closing argument, especially when Robbie Kaplan, who's been on my show, and I've had E. Jean Carroll on my show as well, looked at the jury and said, send a message. He's continuing to defame my client, send a message. He's a billionaire, write a big check. He got up, buttoned his jacket, and stormed out. The optics of it were terrible. It's in a case about sexual abuse with a female lawyer for E. Jean Carroll that he had been abusing as well, and that got shown in a deposition video that was shown to the jury. To then stand up disrespectfully, a misogynistic way, and walk out on the closing argument, which only reinforced that she must be telling the truth because he's upset and he's leaving. And I asked E. Jean Carroll, when do you think the jury was with you? When did they side with you? When did they make the decision to side with you based on the presentation? And she said it was when Donald Trump stood up and walked out on Robbie Kaplan during her closing argument. And he did it again today. Now, I don't think the 9 justices are as affected by his, I think it's more of a eye roll, please, lack of decorum. You know, I don't think they're like, oh, I'm going to vote against him now. They were going to vote against him anyway. They had no problem leading most of this vivisection of John Sauer right in front of Donald Trump. It was like watching a live autopsy of somebody. And it couldn't happen to a nicer advocate in John Sauer. So we're going to continue to follow it all right here. Thanks for being on Legal AF. And by the way, you can help. We're up for the Webby Awards. We made the Intersection podcast, my podcast on Tuesday nights, and the Legal AF podcast got into the top 5 of podcasts, new podcasts for the Intersection, news podcast for Legal AF. We're a top 5 finalists. That's it. And the People Choice Award part of it over the next 2 weeks, if we can keep our first place position, we'll win Best New News Podcast, Best News Podcast, Legal AF, and Intersection. With your help, we'll get there. Take a minute. The link is below. It's all for free. You can only vote once in each category, but vote now and get send this off to other people in your life, get them to vote. And hopefully in 2 weeks, I'll announce that we won. And what the most coveted award for me is the one coming from the people and from our audience, that we won the People's Choice aspect of the Webby Awards. We'll go accept it on your behalf in New York, and it'll be a great moment for our community. Appreciate all of you. In the meantime, I'm Michael Popak. For those that celebrate, happy Passover.
And ladies and gents, as you watch with me, there's 2 videos right here. Now it's time for me to give my 2 cents. All right. First of all, I want to say is this. You know, I hate the double standards, because when it comes to the Republicans and the MAGA, everything that favors them, they are for the Constitution. But the Constitution said this, the Second Amendment, and this and that, yada, yada, yada. Now, the Constitution is very clear, but some that do not like it, you know, now they're going to, oh, no, whatever Trump says goes, no, that's how it should be, yada, yada, yada. You know? So, and talk about when Roland Martin was standing, now, he was saying, Scott, hold on for a second. Even though that's what the Constitution say, but who are you dealing with? You know? So talk about MAGA breaking the law. Look what happened to Pam Bondi. You know, with the Epstein files. She tried to, over 3,000, I believe, if I'm not mistaken, so over 3,000 documents, page that she not released. She say, you know, that's, you can Google. She said that, I don't want to press the charge because it can affect too many important people. You know, and that's video her first, as soon as she got the job, and talk about Epstein files, she said, I got the Epstein files on my desk, right here to be reviewed. It was on Fox News. But then all of a sudden, there's no Epstein files, there's nothing to see over here. You know, the same way this guy on cockeye, Kash Patel on the FBI. So this administration and everybody that's in power, in my personal opinion, cannot be trusted, because they are there to kiss Trump's ass, and that's exactly what Trump does. You know, if you don't kiss my ass enough, I'm going to throw you under the bus. Now, what's up, Christy Noe? Gone. Pam Bondi now is gone. You know, Kash Patel, I believe, is the next. You know what I'm saying, ladies and gents? So you can be just in favor of the Constitution, in favor of the Bible, you know, in favor of whatever, because when just benefits you. And then when it comes to talk about all those people, now minority protection, or now you got a problem with the Constitution. Doesn't work like that. If the Constitution is the main document of the United States of America, so it should apply to all, regardless of Republicans, Democrats, or Liberals. Is that what the Constitution say? That's clear in the conversation. And personally, I don't know why the Supreme Court decided to hear this case. I don't know. I will not say that if the majority of the justice were appointed by a Democrat, Biden and Obama, and then the only thing I could say is they may be the one try to whoop Trump's ass big time on national television. But the same token, you got to be careful about it, because I'm just give an example. The senator from Pennsylvania, his name is Fetterman. That got elected as a Democrat. A lot of votes. A lot of people were support him, believe in what his agenda at the beginning. But all of a sudden now, everything that he does and his vote, you know, in favor of whatever the Republican agenda, the GOP agenda is all about. And he's about to have his ass kicked out too, because people got fed up in Pennsylvania about how he's reacting and how he's voting. You know, so ladies and gents, you can, like I say, you cannot have double standards for the Constitution is concerned. Right? You like it or not, that's the Constitution says it's fine. For instance, like Roland Martin break down about the Second Amendment that talk about the weapons for militias, but they turn around and everybody now can have a weapon. My personal opinion, being a veteran, I trust, to me, only two people should have guns. As far as the military and the police, some type of guns. And if the individual, the regular citizen, want to have a weapon for protection, you should have two types of, I would say 3 types of guns. Number one, it would be a 9mm. Second one would be a shotgun. And the third one, for those that like to hunt, you should have maybe 1 or 2 options for hunting purpose. That's it, in my personal opinion. Because you do not need guns on the street, especially the weapons of mass destruction. That's why I have all this shooting in schools, kids got killed, excuse me, and all this stuff. Because, you know, you don't need that on the streets, period. Now, for those people that want to have this weapon, or mass destruction, why you not sign up for the military right now? Come on, they're waiting. Come on, Michael. Go ahead and go to the next recruiting center. The Army, the Marines, the Navy, the Coast Guard, they're all waiting for you right there to fight the orange pedophile war. If you want a weapon that bad, right? So sign up and go die for your boy. So that's what I'm saying, ladies and gents. So I like this videos right here, ladies and gents. I believe they gave some great information. I told you before, the first ones were before the hearing, and the second one, Michael Popovic. What's his name? Michael Popak. I believe that's how I pronounce. You know, great. So subscribe to their channels, ladies and gents. The link of their channel is under my description right here. And if you like this video today, ladies and gents, please do me a favor, click on the like button. If you're new to my YouTube channel, just subscribe. I appreciate your support. And if you like what I do, ladies and gents, after subscribe, just share this video with at least 5 people you know. All right? I appreciate everything they'll do for this channel. Thank you very much. So please be safe, be kind, and be blessed. And do the best what you can do with what you got. Salute. Enjoy your weekend. And I'll see you next Saturday. Holla!